Very good afternoon, gentlemen. And there is paucity of time, they say. In fact, 20 minutes had been given to me, and for time constraints, it has to be cut short. Therefore, in order not to skip the key points, I have put it in the presentation mode. Please cooperate. So the functional area challenges, and I am expected to represent a constituency of the judicial officers who are now being confronted with a limited jurisdiction, or rather a limited supervisory jurisdiction over these arbitration proceedings. To what extent it is welcome? We know the basic feelings, and we will go by that. What is the basic dilemma? What is the basic dilemma of a judge who is confronted with this limited supervisory jurisdiction over the arbitration matters? That is this. It is this. Please see that. It is this. We are here to litigate the arbitration clause that was meant to avoid litigation, yes. For obvious reasons, you wanted to avoid this cumbersome procedure. If you call it like that, it is okay. Cumbersome procedure, and you have included an arbitration clause in your agreement so as to avoid the litigations, and you are now on litigations. This is what is happening, courtesy to Google Images. This is the basic dilemma. I will have to hurry through. Okay. And that is it. In fact, this is a concluding portion of the landmark judgment of that associate builder's case. And Lord Mansfield had to advise a general. And he said, you can read it if there is time. You can read it. And what I understand is this: he asked the general that he is a man of good heart, good reason, everything is there, he will reach an apt decision, right, all that okay. But he says, be careful not to assign your reasons, since your determination may be substantially right, although your reasons may be very bad or essentially wrong. This had been an attitude. I would say this had been an attitude. It's not, is it the present scenario? Does it represent the present scenario? It doesn't represent the present scenario, because in courts, especially that's it. Now, what this presentation is not about, that also I must say, it is not about any statutory provisions. I will not quote any statutory provisions, and there will not be any case law discussions, and there will not be any claim as to infallibility or otherwise of the system, right? Now, what are the key functional areas of the principal civil court? So the principal civil court of original jurisdiction exercise this limited supervisory jurisdiction over arbitration matters. This is a scheme of the arbitration statute as it stands at present. So first is, in a separate judicial proceeding, be it a suit or other proceeding, suppose it is brought to the notice of the court that there exists an arbitration clause, then reference is a rule. This is one thing which we will come later on. Now, the grant of interim measures. In grant of interim measures, there is a lot of obscurity around grant of interim measures. You know, two mechanisms are parallelly running virtually at times. That's it. Then, interim orders are being appealed to. Interim orders are being appealed to. That is yet another paradox which we come through. That's it. And setting aside of awards. You know what is happening around section 34. And there is then the enforcement of awards. The entire scheme of the statute does not recognize a thing called execution. It does not ever mention about a word execution, because it is very clear, the UN Citral does not at all mention about execution. That word execution is alien, French and Greek to them. They speak only of enforcement. What is the point of enforcement is another nuance behind the system, right? Well, in what should be the base principle for a judicial officer exercising, for a judge exercising his powers under these realms? There is a base rule. There is a base principle of minimal judicial interference, and that is contained in section 5. I have hyperlinked to section 5, but I am not going into it. Section 5 is hyperlinked there, but I am not going into it. It is as good as Article 5 of the UN CITRAL. It's distinctly worded, right? There is no, I'll show you. I can show you that. Yes. So, notwithstanding anything contained in any other law for the time being, no judicial authority shall intervene. That is a basic rule. That is the rule here. And Article 5 also, in almost similar words, speak the same thing. Speak the same thing. That's it. So we have it. The base principle is this: minimal judicial interference. It's a question of discussion. We have doubt whether judicial interference had been minimal or not. We have doubt. And then there is it. The reference of parties to an arbitration. I said I do not wish to show the statute as such, even though that is hyperlinked down here, there, but I don't wish to go into it. For time constraints, it's it. What does it say? It should be not later than the date of submitting his first statement on the substance of dispute. See, the thing is this. In an arbitration matter, who is sitting in judgment? Supervisory jurisdiction judgment. The person who is sitting is a seasoned judge, right? He has his own moorings. He has, first of all, his mindset is not that clear to accept a thing called limited supervisory jurisdiction. It's it. He has been a trial judge and he has been an appellate judge. He knows how to reappraise the evidence. This is a basic trend prevailing there, a mind exercise. And they say the first statement on the subject of dispute, what is that first statement? Is it the written statement to be understood precisely? Now the position is settled. It is a first statement of substantial defense. First statement of substantial defense. And in one case, they say that, one case there is a judgment that I had filed a statement which said that this is only introductory and my other arguments are to follow. It is not. It is not the first statement. And in an injunction petition, there has been a temporary injunction petition and an objection has been filed, then it is a first statement. What is the first statement of defense? If the legislature wants to make it clear as to what it is, basically, the Indian law knows about only the pleadings. The pleadings are the king. Pleadings are the king in the civil jurisdiction in India. Right. So, what is it meant by the first statement? Is it the pleadings? Then it should be written like that. Is it the very first statement, whatever be its of its type? Then that has to be made mention in clear terms. It is not clear. It remains obscure, that's it. Then another question is referring the parties to arbitration. The position is very clear. You can just refer the party to arbitration and you cannot name it. That naming is an exercise which the higher courts are doing under section 11.6. It's very clear. But referring of a person to arbitration, referring is also a word found in the UN CITRAL, but here the same word is used. This at times goes to make confusion. And there is reference. And my point is that what is the legislator's intention? If the legislator's intention is to understand it to be in the terms of the very first statement, that has to be stated. That has to be made clear in lucid terms. That is it. Now under section 9, there are interim measures, etc. by courts. Now as it stands, it now states what? It can be before or during the arbitral proceedings. The case law is the one hyperlinked there. I'm not going to it. Arbitral proceedings at any time or at any time after the making of the arbitral award, but before it is enforced. How come an enforcement is to be understood? Suppose there is a judgment, suppose there is an award come, and an execution petition is, or rather an enforcement petition, whatever it be, is pending there. Do you go to mean that the enforcement has been done? Look, these points have to be, of course, case law is available. But the knot of the case law is this. Viewing from the functional aspect, what I understand is that the knot of the case law is that it covers only a particular set of facts. And if you have a personal opinion, which is not expected of a judge, if you do have a personal opinion, of course, people are, they are also men. They may have personal opinions. If you have a personal opinion, you can find reasons as to why the other precedent shall not apply. So the precedents basically, rather than falling on precedents, we can make things straight. This point is at another point for my suggestion. And here, it says, the court shall not entertain an application unless, that's it. Once an arbitral award, arbitration is set up. Once an arbitral tribunal is set up, then what about the parallel jurisdiction under Section 17? Under Section 9. The answer is there in the statute itself. It says the court shall not entertain an application unless there are circumstances existing which put the judge to think that it shall not render the remedy provided under Section 17 efficacious. Under Section 17 efficacious. I am told about an order in which it had been written. The arbitrator that has been appointed is quite aged. It takes a lot of time, and this is one reason as to why the remedy is not efficacious. Things can even go to that extent. This is just I have never come across such an order. I have heard about it, but things can happen like that. That's it. How come an efficacious? What is the standard actually needed there? Because as I said, this is not a question of the whole jurisdiction. It is limited supervisory jurisdiction. When you are exercising a limited supervisory jurisdiction, it is always fine and good that limits have to be drawn in clear terms. This is my point. Now Section 34. Section 34, the master of all. And that is an application for setting aside an arbitral award. There are criticisms coming up that why a district judge must be endowed with this jurisdiction to topple down even the awards passed by retired Supreme Court judges, right? Probably that may sound reasonable. I'm not up to any opinion on that. Only thing is that the principle behind it is this: the principal civil court having original jurisdiction is authorized to exercise that function. If that function is there, and then the regular court procedure is here, then the principal civil court of original jurisdiction has to do it. That is how come district judges are there, right? And in ultra vires matters, in matters wherein the arbitrator goes ultra vires to his terms of reference. Now, the statute says that if the remedy that he has given for that ultra vires portion is separable from the other side, then the arbitral award can be set aside only to that extent. This severability, or rather separability, also exists there without any standard parameters. So it may depend, it may vary from judges to judge, right? Even that may that may vary from judges to judge. Of course, there are precedents on the point, but as I said, it's always better not to bank upon precedents. And when it comes to the legislative statute, whatever be the legislative intention, that has to be made clear. That's it. And then public policy had been there. There was something called public policy, which they mentioned under Section 34(2)(b)(2). And public policy, it is now defined with an exhaustive definition, as found in the explanation 1, if I remember correctly. Explanation 1, it is there. But even in explanation 1, there is another nuance. It says about contravention with the fundamental policy of any Indian law. Contravention with the fundamental policy of any Indian law. There are umpteen decisions on the point. And if you remember, yes, those all many of these judgments I had hyperlinked, but I am not going to it. I will just speak about the decision, what the decisions say. Such and such is the fundamental policy of India. Here the other side, observing all the alterum partem is fundamental policy of India. And instances have been given that these and these and these are the fundamental policies of India. And see that in the case of a limited supervisory jurisdiction, such a great tool is given to the hands of a judge. at least there must be a definition. At least there must be a provision so as to make an inclusive definition of such and such are part of fundamental policy of Indian law. That can be done, or otherwise it is too general a term, and that cannot be trusted to be left to the personal. What is it? I have the words, but no, you know my limitation. But I cannot be left to the personal whims and fancies of a judge, right? That's it. Two generalized terms are still used. Fundamental policy of Indian law. And then, in the explanation too, at the same time, at the same breath, it says that it shall not entail a review on merits. It shall not entail a review on merits. So, one side they say that it is fundamental policy of law, how come it is applied? And here it is, that cannot be a review of merits also. So, however, the decisions on the point are very clear. And therefore, in granting of these orders under section 34, almost all positions are now well settled. But as I said, each case has got its own its own factual basis. And that makes the difference. Now, going by section 34, now explanation 3 gives another thing, another wonderful thing, and that is when it is against the most basic notions of morality of justice. Most basic notions of morality or justice. Morality, even as per the Indian law, they first banged on the Hicklin rule, and now it has gone to a greater extent. As times pass by, the standard of morality, the parameters given to the term in understanding that term morality has gone high. So at the same time, this word is again there. If you go by the case law of morality on the point, Hicklin rule has been given a go by the tendency to corrupt and deprave the minds of those persons whose minds are open to such illicit influences. And it's all gone. It's all. Now the three-way prong test, that is here. Even if that is used, then the term used is most basic notions. How do we go to determine the most basic notions? And the case law, even though case law is there, it's not that much. It's not that much. In the associate builder's case, it is treated as a separate head, but it is not that much. And then section 34. In section 34 also, another point of confrontation is that patent illegality, the test of patent illegality. It's almost clear. It's not as bad as the term basic notions of morality or justice. It's not like that. Patent illegality is something understandable. But still, there are there has been order. The orders are being passed which go against these fundamental notions. The very reason is that these words have been given in a too general parlance. It has to be, at least inclusive sort of definitions have to be there for these terms. That is what I meant. Now going by section 37, there are all appealable orders. Now in appealable orders, granting or refusing to grant an interim measure under section 17. That is made appealable under section 37. And section 37 is there, hyperlinked. Why? There is a paradox, there is a paradox. Especially in matters, when coming to the practical scenario, we see many arbitrations even based on that copyright violations, intellectual property rights, everything, etc. And in such cases, what happens is that often the interim measures are the most important things. The interim measures are once you get an interim measure, that is done. The purpose of the arbitration will be done. Such sort of cases are there in a lot many numbers. So once an arbitrator spares his intelligence to pass an order as to an interim measure, it is still appealable. Same evidence is being let in. And in the main case, the folly is that in the main case, a judge is never intended to go for a reappraisal of what the evidence. But at the interim stage, you are permitted to do that. Same evidence is being done. And consider the fate of the situation, consider the fate of the parties, especially in very emergent matters. This thing is there. Why should there be an appeal? Why should there be an appeal from an interim measure given? Which I do not express any. I'm not the one to express any opinion on that. But this knot is there. That has got to be addressed now. And under section 17(2), enforcement. It comes to the word enforcement. It does not speak anywhere about execution. Execution is a word which is French and Greek to this, the entire scheme of the Arbitration and Conciliation Act, and as well as the UN Citral, on which the Arbitration and Conciliation Act bases. It seems it shall be deemed to be an order of the court and shall be enforceable under the Code of Civil Procedure, as if it were an order of the court. As if it were an order of the court. Now, after the Pradeep decision, it is settled. Then under section 17(2), you have to approach with an enforcement petition and not with an execution petition. Forms are all important for a district judge. Because even using an irrelevant form may bring in atrocious conditions. That is it. So under section 17(2), what should be the procedure? If you are you going by the execution, for as far as an order is concerned, still there are provisions as to execution. So for what you have to go? You have to go in under section 94 CPC, or you have to go in for under this thing, order 21. This has to be specified. It has not been specified yet. And the need for a special court, that was another functional area challenge which we used to face. The need for a special court, because in almost all arbitration matters, it reveals a high level of high informed level. Those will be about, those will say for example, sometimes those will be about a violation of intellectual property rights. So that needs a high informed level of thinking. So you are expected to make a supervisory jurisdiction into it, and once you are expected to make that supervisory jurisdiction, you will have to be informed to that level as well. So it was found good that one of the district judges court be made as a specialized court for arbitration, at least. So that aspect is now being addressed by the Commercial Courts Act, Section 10. Now, under Commercial Courts Act, Section 10, in every district, one regular district judge court shall be nominated as a commercial court for the purpose of this arbitration, limited supervisory jurisdiction under this Arbitration Act. And here is it. The section goes like this. And the section goes like this. Anyway, that has not been enforced yet. There are, this provision is in the anvil. It will soon realize, I hope. Now, the establishment of this Commercial Courts Act, especially Section 10, establishment of these commercial courts would address the time constraints and specialization constraints, which I said. A basic issue that is confronted by the principal civil judges of the districts is this. They are allotted with a wide range of jurisdiction, civil, criminal, arbitration, everything. The original side is there, appellate side is there. They have to conduct sessions trials, they have to hear appeals, criminal appeals as well as civil appeals. This wide area of jurisdiction, and they are expected to go into this for the very, very, very subtle facts given in arbitration matters. And that is a very, very, very pathetic condition. Basically, that was a deplorable condition, which I think the Commercial Courts Act, Section 10 is going to address. Well, I think I have violated the time constraints, right, for presenting this matter. Okay. So that's it. Thank you very much for the audience.